Hello, can everybody hear me? Hello. Hi, evening. Thank you very much for joining us on this sunny evening. We appreciate your time. We couldn't have picked a better day for it. My name is Victoria Snell. I'm one of the owners of Harris & Hardy, along with my business partner and husband, Andrew, over here. Hello. You may know that whilst the business is now 25 years old, it's been in our ownership for the last 4 years. And in that time, we've seen the lettings department go from strength to strength under the diligent management of our lettings director, Sharon Haynes. Sharon, are you here? Give us a wave. That's great. So we've got all the lettings team here tonight, if you can all give us a wave. We've got Ella, who's our lettings manager in Morton. There she is. Lovely. Sarah, our senior lettings negotiator in the Borton office. And importantly, Ildiko, our property manager. Ildi, where are you? There she is. So please feel free to meet the team and ask any questions that they can help you with this evening. Andrew and I have a relatively long and untarnished history, well, relatively untarnished history in property, but a majority of my 25-year tenure has been in residential lettings. So I've seen all sorts of changes over the years and definitely gained a lot of experience in that time. We're always looking for ways to progress and develop our level of customer service. So this seemed like a great opportunity to go that extra mile. This is our first landlord event, very exciting. And in light of all the changes upcoming and recent, mainly legislatively, we thought it might be really useful to have an information evening for all our landlords to help educate everybody on the changes and the implications, and hopefully be able to offer some reassurance in light of the significant changes ahead. We've got a fantastic lineup of professionals this evening. Firstly, we have Claire Speed from Hedges Law, who's going to talk to us about the Renters' Rights Bill and what we can expect from the implementation. Thank you. And then we've got Indy Bansi of Esher Mortgages. Here's Indy, who's going to talk through buy-to-let financing, what's happening in the mortgage market, and really how the changes in the legislation are going to impact the mortgage market for landlords. After each speaker, we'll have a 10-minute question and answer session, so have your questions at the ready. But their business cards, I believe, are... brilliant. They're in the bags, so do feel free to contact them in the future if they can be of any assistance. So thank you again for coming. On that note, I'll hand over to Claire and she can update us on the renters' reform or renters' rights. Thank you.
Hello, everybody. Can you hear me okay? Good, good. So I am Claire Speed and I head up the dispute resolution team at Hedges Law. We have offices based in Chipping Norton, Wallingford and Summertown. And as Victoria said, tonight I'm going to give you an overview of the Renters' Rights Bill. So I suppose to start, how many of you are actually landlords? So quite a few of you then. So you're here, you might know already a bit about it. So hopefully you'll know a bit more after this evening. I will say as I go through, these changes haven't come into force yet, so they are still subject to change. But we will tell you tonight as much as we know at this current time. So tonight we're going to discuss the key changes the bill will bring about, the most recent updates of the discussions that have gone through the Houses of Parliament, the consequences if you as landlords don't apply, and how we can assist. So there's several key changes and there's a lot for you to take on, and that's why we'll have the question and answer session at the end. Essentially, these are the widest reforms which will affect landlords in the last 40 years. There has been talk of these reforms in the previous government. The Conservatives were going to introduce the Renters' Reform Bill. The Labour government came into charge and effect, and they have implemented this bill, the Renters' Rights Bill. There are subtle changes between the two, the main one being that this bill doesn't have any court changes. We were looking for reform from a legal perspective for the courts to be updated, the court system, because it's very slow at the moment, but that hasn't happened and is not going to happen. So once these are implemented, we will have to work with them as the court system stands. So the main key change is that there's going to be the abolition of fixed term short hold tenancies. Now this applies to all tenancies across the sector. All tenancies will become assured periodic tenancies and will run on a month-to-month basis. That is until the tenant served notice or the landlord meets the ground for possession. The bill applies to all private tenancies, whether they are new or they are existing. So that will leave landlords in some difficulty or leave you with a problem that all of your tenancy agreements will need to be updated as soon as this is implemented. So the tenants have a certain level of protection already. As you know, as landlords, it's difficult to evict a tenant. That is getting stronger now. So during the first 12 months of any new tenancies, landlords will not be allowed to move back into their property or attempt to sell it unless they are selling it to another landlord who will take over the tenancy and the tenants. This means that essentially the 12-month period for the new tenant is protected. The tenant can, though, serve notice if they want to bring that tenancy to an end earlier. Tenants will be required to give 2 months' notice to the landlord to leave, and that's got to be in line with the rent payment dates. If the landlord said he wants or she wants the property back to sell it, there is going to be provision that they can't re-let it, so they can't use that essentially as a reason to get the property back because they can't re-let it within a 12-month period. There's going to be a limit in terms of rent increases. So that means that you'll have to serve a Section 13 notice to raise the rent limit, and only 1 notice can be served per year. And it gives the tenants the right to challenge the increase in the tribunal if they think it's not a market increase. The key provision is the removal of a Section 21 notice. You all know at the moment that a landlord can serve a Section 21 notice using a no-fault ground, which basically means that the tenant has 2 months to vacate the property, and if they don't vacate the property within that time, as long as the landlord has complied with all of their obligations, it's a tick box exercise for the court to get the property back. That has been abolished. And now the only route under this, once it comes into force, will be for a landlord to serve a Section 8 notice. The Section 8 grounds are essentially fault grounds. They are currently being updated and changed. At the moment, the changes are that you can still evict with regards to rental arrears and antisocial behaviour. At the moment, the rent arrears has increased from 2 months to 3 months, and the notice period has been extended from 14 days to 4 weeks. So they haven't been firmed up, all of the mandatory grounds, but they are going to be changed, which will mean that you will have to, as a landlord, make sure that you make out one of those grounds for possession. There is a ban on rental bidding wars, so landlords and agents will be required to advertise the rental price and won't be able to accept offers above that price. So that negates any sort of bidding wars, which because there is a shrinkage in the properties available for letting at the moment, it has increased prices and has meant that there has been bidding wars for certain properties. That now will have to stop when, of course, the changes come into force. With regards to deposits, gas safety certificates and EPCs, so energy performance certificates, as you know at the moment, if you wanted to evict a tenant on the grounds of Section 21, you have to make sure you comply with all of your obligations as a landlord for the court to give you that possession order. Landlords under the new changes will still have to make sure that any tenancy deposits are protected, and if they're not, they won't be able to evict the tenant under a Section 8 grounds. The only grounds they will be able to use would be for antisocial behaviour. The rules on gas safety certificates and EPCs don't carry over in the current draft of the legislation. So therefore, if a landlord hasn't complied with them, it shouldn't give them, it shouldn't restrict them from gaining possession of the property. So some further key changes. There's going to be a landlord's ombudsman appointed. That is going to be appointed to resolve disputes between landlords and tenants. There's going to be a private rented sector database, which is basically a central database which will include details about all landlords, the properties, and that will provide visibility on compliance. And what we mean by that is there will be information about particular landlords and whether they have had banning orders, whether they've got any financial penalties or any other relevant offences. And that database will be accessible by tenants, local authorities and landlords themselves so that they can have access to the information as well. Another key change is that they are going to introduce a decent home standard. There's going to be a minimum standard of how rental properties should be, and that's an extension of AWAB's law. I don't know if you're familiar with that. It normally applies to the social housing sector, and Mr. AWAB sadly died in a property which was subject to mould and various other deterioration in condition. Now, that only applied to social housing previously. Now that is going to apply to private housing as well. There's going to be a prohibition on discrimination. So landlords can't discriminate against those that have children or those that are perhaps on benefits, and pets. Landlords can't unreasonably refuse a tenant with pets, but can require them to take out additional insurance. And there will probably be provision in the tenancy agreement to perhaps for cleaning and that sort of thing. So the third reading of this bill took place in January of this year. There were a few amendments to the bill at that time, and there may be further amendments going forwards, but the amendments that stand to date are there's going to be a limit advance rent, which prohibits landlords charging more than a month's rent up front. The Ombudsman's fee, so the cost of the Ombudsman will be borne by landlords through a fee which is placed on the current database. There's going to be a PRS database with clarifications, so that will mean that the landlord, managing agent, address and contact details will need to be included in case any enforcement action against those individuals is taken, and where notices should be served on tenants, etc. Student lets is more of a tricky area, and one for landlords to watch, because the bill doesn't catch it, but what it does do is it means that landlords can evict at the end of an academic year, but they will have to serve notice on the tenants at the beginning of the year, and they need to give the tenants 4 months notice before the eviction date. So it's a bit tricky with the timings of that. So if you do have student lets, that's one to watch, and maybe that area in the bill will change, who knows. And there's going to be increased protection for bereaved guarantors. So guarantors will no longer be liable for rental payments if a tenant dies. So what if you don't comply as landlords? At the present time, I mean, the cases that I see that are coming through to me are cases generally whereby the landlord hasn't dealt with the paperwork correctly, basically. It's they haven't got all of their house in order when it comes to gas certificates, it makes it more difficult in the present time to get a possession order from the courts. I foresee the importance of getting familiar with the new regulations. You've got to be live to the changes and the requirements that are made of you. And if you're not sure, then the best thing to do is have a fully managed sort of property letting service, so you can't fall foul of anything if you do need possession at a later stage. If you don't comply for any reason, then of course there are now fines, and those fines have been increased. And they can start at £7,000 for a minor fine, and we have no guidance on what minor means, or it could be up to £40,000 a maximum fine if a landlord has repeat offences. So the status of the bill at the moment is that it's going through the committee stage in the House of Lords, and in fact they had some discussions on it last week. They didn't make any changes. It is planned that this will come into effect and it will be law before the recess on the 22nd of July. It's expected that from the 2 months of the commencement of the bill as to when that will come into effect. The guidance we're getting at the moment is that there should be some sort of transition period for landlords to help them get familiar with the new rules. And that may mean that will take us up to the end of the year, and perhaps the landlords will have to fully comply by the beginning of next year. But these dates are really sort of vague at the moment, and it depends on what commentary you look at. So we're in some difficulty because I'm not actually talking about something that is law at the moment, it's just proposed. But the guidance seems to be that in the autumn, in September, this should come into effect, but hopefully you will be given a period of time where you can have a transition. So how can we help? So as I say, the key thing is to get yourselves as familiar as possible with these changes when they come into effect, so that you don't fall foul of your new requirements. So in terms of how we could perhaps help, existing tenancy agreements will need to be reviewed and new tenancy agreements will need to be drafted. Businesses will have to look at their policies in terms of letting, so letting agencies, etc. will have to look at the policies that they have and a review of their procedures when it comes to advising landlords in these types of matters. Consider your status of your property portfolio and the risks the bill presents. We as a business, we've actually just been instructed on a matter whereby we are disposing of a property portfolio in light of these changes, so the sale of those properties. Hopefully you as landlords won't take that step, but some landlords are reasonably cautious about these new changes being brought into force and the difficulty they may face in evicting tenants going forwards. And we can also provide guidance on protection of assets, for example, powers of attorney, which are really important in these types of scenarios. In the event that you have an accident throughout a transaction, or when you're actually have a tenant, if you lose capacity during as a landlord or in your day-to-day life, if you haven't appointed an attorney who deals with that property on your behalf if you're not able to do that yourself. So the importance of a power of attorney in this type of scenario is paramount, really. So as I started with, the bill is making its way through Parliament and could be subject to further change. The government does need to consult with the regulator, so there is a regulator that regulates this industry, and of course because of the social housing sector, they also have to discuss matters and consult with them as well. So as I say, we don't have any guidance of what the tenancy and the housing standards should be, and obviously that's going to be paramount for you as landlords to know what the condition of your property is expected to be. But these are all things that will come to fruition, we are hoping, when the bill comes into act later this year. So that's basically an overview, a very brief overview, because we could talk for hours on this subject, to the key changes as how we see matters might affect you if the bill comes into legal force and an Act of Parliament this year. It will be subject to change, and we can provide updates. Victoria will probably provide updates to you as well. But based on what we have discussed this evening, the information we have to date, do any of you have any questions?
Well, I mean, you may have covered this, but is there any anticipated grace period, or do we just think it's going to be the axe down, this is how, this is the new world?
Yeah, we thought that there would be a grace period. I'm surprised that the Act actually deals with existing tenancies, but the government wants protection for all tenants from day one that it's enacted. That will mean that there will be some retrospective work. Now, the guidance that we are and the commentary that we're receiving is that there should be a transition period to allow you to adjust your portfolio accordingly to make sure you've got the right agreements in place and things like that. So if you find yourself in a position where you need to evict your tenant, you're able to do so. But we don't have any further guidance other than that, really.
Thank you very much, Claire. That
No
was really
problem.
helpful.
Thank you all.
Thank you.
Right, good evening, ladies and gentlemen. My name's Indy and I'm an independent mortgage broker. Claire, that was really useful, so thank you very much for going over that. You put everyone in a great mood. What I thought I would do is, because the legislation is of course still pending, I thought it would be useful to give you an overview of the buy-to-let market as a whole. So I thought we'll start with where landlords started, where we are at the moment, and where we potentially foresee it going in the future. So what I would probably start with is the characteristics of what we would call a traditional landlord. So what that means is you would usually see somebody who, generally speaking, purchased the property in their personal names. Average age of a landlord buying in their personal name is 65. And generally speaking, buy-to-lets would be on a single AST. Okay, so about 75%. We had about 13% as HMOs and 12% as multi-unit lets. Now, the demographic of what we class as a landlord now has significantly changed. What we're seeing now is HMOs have increased to 20%, multi-unit lets 15%, and now single lets are only making up 65% of what the market looks like. What we're also seeing is a shift from clients buying in their personal names into limited companies, okay? And that has changed also significantly the average age of a landlord. So now average landlord age is 45, and in the UK today, there's over 401,000 properties owned via limited company. Now that tells us that actually the buy-to-let market has always been an innovative market, but what we might have seen previously are people, accidental landlords, as if we want to refer to them as that. By accidental landlords, what we mean is that they might have inherited a property rather than actively wanted to be a landlord. So they might have one or two houses. It might have just been a side hustle, if you want to refer to it as that, a sideline of income, not their primary source of income. The new landlord, well, the limited company, that suggests to us that they're in it for long term. And as Victoria's just mentioned, landlords at the moment, if they are buying into limited companies, often that's an indication that they're here to stay. Okay? It also tells us that they're a more sophisticated landlord. Now, what that means overall are all these potential issues, if you want to refer to them as that, that we see happening in the marketplace with the renters' right to buy, the EPC changes, is that they will be able to take all of these, if you want to refer to them as burdens, upon themselves and continue to move in the market that we're seeing, presenting itself as a limited company market. Now, to be able to support that, in the main, what we would usually see is real specialist lenders in the buy-to-let limited company space. However, to support the limited company broker, we're seeing more high street lenders coming into that space. Just as recent as last week, you saw Coventry Building Society launching into the limited company space. Now, what that tells us is that they foresee more and more landlords purchasing property through a limited company. Now, for those landlords within the room who are potentially looking at limited company options, the reason we would recommend and suggest a limited company is, number one, and first and foremost, the tax relief of the mortgage interest. Okay. Secondly, lower rate of tax on the profits that you're making. So you're only having to pay the profit on any income that you draw in, or corporation tax. If you're a higher rate taxpayer, it's an absolute no-brainer. Buying through limited company makes the most sense. Also, if you're looking at expanding and buying additional property, then certainly buy-to-let through limited company would be the option for you. The most important bit really is the transfer of property as well. So it's the succession planning. If you've got property in personal names, you're going to have a big issue in terms of when it comes to IHT liabilities. Whereas if a limited company, there are still those issues that you will still have to pay the inheritance tax. However, transferring those to, let's say, family members is made much easier than having the property in your own personal names. Also, interest rate coverage on limited company buy-to-lets tends to be less than what it would be if you had a property in your own personal name. So refinancing options are made much easier through a limited company. Generally speaking, rental coverage is around 130% rather than in personal names where they can go up to 145% or in excess of. At the moment, there's 680,000 limited buy-to-lets held in limited companies. That's a 332% increase since February 2016. So you can see where the market is moving. So what we're seeing within the buy-to-let market now is a two-tier system. So we've got personal name clients who are remortgaging property, or they're doing potential product transfers. Very rarely do you now see clients buying additional property in their own personal name. And moving forward, that probably reduces even further. Average age is 65, and they're unlikely to convert any properties that they already hold into the limited company space, just because of all the tax implications that will also go with that. So that's a different set of advice. The other client base is a limited company. So it's a way of buying additional property. It's more innovative. You've got more options. Lenders are supporting that space through green products, through cashback, and also offering to HMOs, multi-unit lets, and supported living. And what we're really trying to highlight there is that there's more opportunity if you are diversifying your portfolio. If you've just got a single let, that's where we're seeing that clients that you're probably not making the rental coverage that's required. And that's where you're thinking of other options available to you. So, future hazards that we see for landlords. We've already touched on the new legislation that's coming into play. Also, we've got the EPC deadline that's pending for 2028. Now, that will potentially cost landlords in excess, on average, of £12,500 per property. Now, a lot of landlords will see that and think, well, actually, there's probably no point of being in this space. Costs are increasing. Lenders are charging more for arrangement fees. There's higher specialist advice. And, of course, I think somebody already mentioned loss of control in terms of who you're able to let your property to. So they're all concerns and hazards that we're seeing within the market at the moment. What I would say is with that, there's always opportunity. And as Victoria's already identified, landlords are very resilient. And if you are serious about buying property, you will continue to do that, or you'll continue to be landlords. So what we'll tend to see is a more professional specialist landlord. And potentially in the future, and I don't want anyone to hold me to this, but potentially there could be some base rate reductions this year. If what we're seeing in industry press is correct, potentially as low as 3.75 by the end of the year. And they will be hopefully positive changes that we'll see that you can benefit from as well. You can also have a look at if some landlords are thinking, actually, this is no longer for us, we want to exit, and we are seeing some landlords selling up. Potentially, you could buy from other landlords, and if you are operating within a limited company space and you're buying from another limited company and you're buying their whole entity, there are some stamp duty clauses as well. So, of course, I would recommend that you get some advice from your accountant regarding that as well. Succession planning is an option as well. So buying through limited company, future options would be worth exploring there as well. And I think someone mentioned here earlier, although you might lose control in terms of who's going to be in your property, ultimately you can have a look at it as an opportunity, because now you get to choose who's going in and you have longer term sitting tenants. So in terms of having a letting agent in place, that is more important than ever. And what I would say to you is that, like I mentioned earlier, landlords are resilient. Lenders are wanting to support landlords, And it's most important for you to make sure that you've got the right support around you. You've got a good letting agent, a tax specialist, a mortgage broker, and of course a solicitor to hand. That's all from me. Any questions?
And how easy is it to transfer, if you are, let's say, an individual with 2 or 3 properties, do you still see the benefit in transferring those properties that are in your name into a limited company?
I wouldn't recommend it, no.
So if you are...
If you've already got them in personal names,
Yeah.
leave them in your personal name. Because if you transfer them, you're selling them to the limited company. As a result, you'd have to pay stamp duty.
Okay.
And
yeah.
of course, you'd have to pay the capital gains on any growth that's been made as well.
Great, okay. And who are the key lenders if you're buying as a limited entity?
So I'm going to say Paragon, aren't I? There's a number of different lenders available. So you've had TMW enter into the limited company space, who are Nationwide's buy-to-let arms.
Yeah.
You've got specialist lenders such as Paragon, Kent Reliant, Fleet. There's quite a significant broad range, and they're growing as well. But
Okay.
I think most importantly, to see that you're seeing high street lenders coming into this space suggests that the competition is growing, and that only can be a good thing for the consumer.
Okay, great. So I know that there's sort of at one stage it felt like sort of mortgage lending was a little bit hostile towards buy-to-let investors, but you're saying that now actually it's a lot more of a friendly environment.
I think so.
Yeah.
Yeah, I think that at the end of the day, lenders need clients as much as clients need the lender.
Right.
And for the right client and the right proposition, lenders are prepared to lend.
Great.
Yeah.
Okay, lovely. Well,
Okay.
thank you very much.
Thank you.
Has anybody got any other more questions before we wrap up for the evening? I mean, we're happy if you've even got any questions sort of just generically for the lettings team, or, you know, again, for Claire, if anything's popped up. If not, all of our business cards are in the goodie bags that you'll be given on departure. So, you know, feel free to contact us and get in touch. I hope you found it an interesting evening and useful. It's certainly been nice to put lots of names to faces. And please do let us know if we can be of assistance. Thank you. Thank you very much.
Thank you.